Okay, we are back. Let's talk about consideration as an overview. So, or actually, let's just talk about where we're up to. And if you've got any questions, we can go back, because I just want to put the jigsaw pieces, puzzle pieces that we've put together on the table for now. So, in order to have an enforceable agreement at common law, we need to have agreement. Agreement is made up of offer and acceptance. Sometimes we can't find offer and acceptance that match, so we look for consensus. And when we think about some of the cases we spoke about today, Lampley and Braithwaite is a good example. That's another way of looking at that, or potentially arguing facts on a case like that might be, it's not a case about consideration, it's a case about whether or not the parties had the requisite intention. Did they actually reach a consensus? And it appears they did. You might not have known exactly what the price was, but there was an intention to pay a fair price. So we have offer, which is matched before it's withdrawn with an acceptance, which doesn't seek to vary the offer in any way. And an agreement is made at the time and the place where acceptance is communicated to the offeror. At that point, we have a contract. In order for that, so the offer itself needs to encapsulate these other elements. So the other elements are consideration, intention, and certainty. So consideration, we've pretty much finished our discussion of it today. And so consideration needs to be sufficient, but it doesn't need to be adequate. So what does that mean? That means that it needs to be something that the law recognises as being valuable or being sufficient to demonstrate an intention to enter into a formal legal relationship. Now, there are all sorts of exceptions, all sorts of circumstances where you don't need that. The very first one is you could use a deed. So many of the problems that arose in the cases that we had today could have been very quickly fixed by putting together a deed that says this is what our new arrangement is, and signing the deed. We don't need consideration for that. So when those poor old sailors went off to CCC and changed their arrangement when they were coming back, if they'd put a deed on the table and got that signed, we wouldn't need any consideration. Similarly, with cases like Musumeci, Williams and Roffey Brothers and Williams, I will not get that round the right way. Even Hartley and Ponsonby, all of those cases could be fixed by just having a deed. But when we're in the common law world, we assume we haven't made a deed, we're just making a contract. Now, a contract could be made verbally, or it could be made in writing, or it could be a little bit of both. Then we need evidence of the consideration. So consideration does get itself wrapped up. It needs to be part of the offer, because the offer, in order to be a valid offer, needs to be capable of creating a contract just by being accepted. So all of the DNA of the deal, they're my words, not a judge's, the DNA of the deal needs to be encapsulated in the offer, which means the offer itself needs to be clear what the consideration will be. Now, an offer is usually an offer to do something for someone else. It could be as simple as that. The to do something might be to pay money. So when I go into a shop at the moment to buy bottles of wine, I am offering to pay money in exchange for a bottle of wine. Okay, so, but the consideration needs to be clear. Now, often, when you think about it in real life, you don't actually know exactly what the price is going to be. When you sit down, you might, how many times have you walked into a cafe and just said, you know, I'll have a coffee, and not known exactly what it is? But there is an intention to pay. In fact, in my case, it's more likely go in, I'll have a glass of the house red, and then, you know, and the bill could be anywhere between, well, I'm not fancy, anywhere between about $6 and $30. It's big range. I don't know what it's going to be. But it's still the offer, I'm going to give you money for your wine, still encapsulates that consideration. But you can see how they are linked together. So a big argument for why we have consideration is because in order for the courts to be bothered going around and enforcing somebody's agreement, they need to understand or be able to see that there was an intention that the agreement be legally enforceable. And consideration is the argument for consideration is it demonstrates an intention to be bound. And that even the act of saying peppercorn consideration, $1 consideration, even the act of doing that demonstrates that the parties have turned their mind to whether or not they expect this agreement to be enforced or not. Now, intention is actually, we're going on to that next, and spoiler alert, it's very rarely a big deal. Most of the cases you'll be dealing with there are quite old, they deal with families and social relationships, but since the 1980s and the case of Irma Genus, really there's very little that's contentious about intention in Australian law. And then we will move on to, actually, we're doing intention next or certainty? Can't remember. We do certainty. I think we do certainty. Can't remember what order we do them in. But certainty really will close all of this off for us, I think, because part of making sure that we've got an offer or an agreement, but offer in particular that is capable of ripening into an agreement just merely by being accepted, requires it to have sufficient certainty and completeness. So certainty is actually made up of a number of different steps, but it's about working out, are there real promises in this being made? Or is it just the terminology we will use is illusory promise, but is it a real promise? Is it a promise that's capable of being enforced? Secondly, is it clear? Is it clear enough what the parties meant by these words or these actions, what the contract's about? And is it complete? Are all of the important things included? And so we call those the material terms effectively, and usually they will include things like price, because we need to have consideration in order to have a deal. What the subject matter of the contract is. It can't, I'll sell you a house is not the same as I will sell you lot number blah 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 on block X, address Y. So are all of the things we really need to know encapsulated in that offer? So as we work out through all of these steps, part of what lawyers are thinking is, how do I avoid all this rigmarole? And I guess that was one of the points I was trying to make earlier, particularly when we're looking at how the law will work through a particular set of circumstances. Doesn't mean you should plan for that. You might be looking for that out when your client hasn't planned for it, but if you are trying to put an agreement together of some sort, you don't want to be relying on a court to subsequently find that there was practical benefit, or that there might be some promissory estoppel that you can, because somebody's acted in reliance. What you want to be doing is saying, okay, where is this a bit grey around the edges? Do we need a deed? Do we need to change this around in some way and just make sure that there is an additional document where the parties have said, we've agreed to vary our original contract by replacing the price X with price Y and time for payment with price Z, and as evidence of our intention to be legally bound, the person who's getting the benefit of the price reduction pays $1. So can you see how we need to start to pull all of that stuff together? So again, as you're looking at your problem tasks, and again, quite possibly less so with this one with the next than there will be with the next one. So with the next problem and I'm talking about the assessable assignments here, part of the trick to that will be that you're going to give your client some advice about how to make sure that an agreement is binding in the future. So the easy way to do that is to change some words around and, you know, to tell him about practical benefit or whatever. But actually what's going to make good lawyers stand out is to maybe even go back to first principles and say, okay, do we need a deed? Do we need something else here? Okay. The other thing I should point out to you, just because I'm mentioning deeds, is, and I'm sure it'll come up on a slide later in the semester, but at the moment showing slides is a bit of a pain in the bottom, but we'll work that out. Actually, I'm thinking out loud. I wonder if I used Google Slides, if you guys would be able to see them on a different device and I wouldn't have to share. Anyway, we'll sort that out later. In the course notes document, there is a table that shows the differences between deeds and standard written agreements. So how they're similar and how they're different. There's a couple of things in there, as I said, it'll come up on a slide at some point. But one of the things that is interesting is that in most Australian states, a deed will be enforceable. So the statutes of limitations period is much longer. So a statutes of limitations period is basically the amount of time that you have between a wrong being done to you, a breach of contract, for example, and when you can bring a claim or in a court as a consequence of that right that you have to sue for breach of contract. Now, in general terms, and don't quote me if I'm wrong, but generally on a standard agreement, that is about 6 years. Varies a little bit from state to state. 6 or 7 years between the harm being done and the claim being made. In Victoria, for a deed, it is more than double. It's around 12 years. In other states, it's less, but it's different state by state. Have a look at the table. So that's a significant difference, which I often like to point out to you guys, because that's often a trick for young players, and it makes you look good when you're being an intern or you're working at a commercial firm, because people in firms forget that stuff all the time. So just a little tricky play. Okay, that's pretty much all I've got for you, unless you've got questions for me, which you usually do. But if you're ready to go, nobody out there is making dinner, so I'd quite like to talk for a little longer. Oh, Holly, you weren't waving goodbye. You were saying, I've got a question.
Yeah, I've got a question. In the textbook, there's on page 111 for 105, there's a thing about termination, and it says, like, if you terminate an existing agreement and make one where the beneficiary party has the exact same obligations, and the modifying party has different ones, it's still a valid contract because it's a new contract.
Yeah.
Does that count if you terminate a contract and then pay less of a debt? Like, are you allowed to do that?
Yeah, because you're the modifying party there. So if there was, really good example. So the Pinnell's case type example, that example that I gave you right at the very beginning, I owe you $1,000. We just agree that you could agree with me that you weren't going to claim the balance if I pay $800 by next Wednesday. Now, if I'm smart, I'll say, good, let's terminate the original agreement and have a new one that says I have to pay you that, because then I'm home and hosed. But if I'm not smart, or I don't have a good lawyer, I just agree that you will waive your right. But if you don't want to waive your right, you don't have to waive your right unless we've terminated, or unless I paid fresh consideration for that.
Okay, thank you.
But a new agreement, there still needs to be consideration moving from both sides. So it would be usual, if you were documenting that, to either do it in a deed or to actually stipulate that the parties intend that the agreement will be binding, and it might be that the person who's getting their right, like the amount that they have to pay reduced, then they might, pay $1 for that. Or sometimes you even see the words for consideration, good consideration that acknowledged by the parties, something vague like that. I've seen those words. The other thing is, if the amount isn't due yet, another way that can happen is, so if I owe you money and it'll be due next Wednesday, and I come to you and say I'm not going to be able to pay that, if we agreed that I pay you $800 today in full and final settlement, then we would have fresh consideration, because I've agreed, I don't have to pay you anything today, but I'm going to pay you $800 today instead, and you've agreed to reduce it because both sides are getting something.
And that's only if both parties agree?
Yeah.
Okay.
Cool. Yeah.
I was going to ask about that as well, so you answered my question.
Cathryn, can I ask a question?
Yes, please.
With an invitation to treat, is that always made to the whole world, or could you specify a smaller group, or even 2 people or 1 person?
Absolutely. So often invitations to treat are only made to a small selection. So, for example, members of a club. So if you were a member of the RACV club, it offers discounts on holiday theme parks, which of course all of you are sitting at home planning to go to at the moment. The pricing that is offered, or the invitation to treat, is an invitation to treat, to purchase discount holiday tickets, but the only people who are able to make offers to purchase at that invited price are members of the RACV club or the entertainment book or whatever it is. It might even be that you might narrow it down to 1 or 2 people. So I could, if you and I were having a conversation, I could offer to sell you this, and I could say, along the lines of, I haven't spoken to anybody else about it. I'm thinking that I would be prepared to accept offers of $100 or more. And you're the only person who knows about it so far. But it wouldn't necessarily be an offer to the world. Or only the people in this webinar at the moment know I'm prepared to accept offers of $100 or more for this. It's this very small group. And I can decide that I'm not going to accept offers from anybody else. Cigarettes and alcohol. Invitations to treat are bound, but offers will only be accepted from people over the age of 18 who are not drunk.